In January 2008, two uniformed police officers were patrolling a neighborhood in south central Los Angeles in an unmarked car. The officers saw three men they didn't know standing on a sidewalk in front of a house about 75 yards away. The officers went to the house and stood on the sidewalk and attempted to talk with the men, who had moved into the fenced yard area. One of the men, Nora, appeared nervous and stood stiffly with his right side hidden from the officer's view. Seconds into the conversation, Nora turned towards the front door and ran into the house. The officers could see that Nora was holding a blue steel semi-automatic handgun in his right hand. One of the officers shouted, "Stop, police!" But Nora ignored the command, rushed into the house, and shut the door behind him. This week's topic is about the United States versus Nora, a 2014 Ninth Circuit Court of Appeals case involving Fourth Amendment violations when calling someone out of their home. I'm Steve Cerbalic, and I'm a panel attorney for ASCOPS in Arizona.
Negative.
Officers surrounded the home and called Nora and the other occupants out of the home over the course of 20 to 30 minutes. After Nora came out of the house, he was handcuffed, searched, and Mirandized. Nora admitted to small amounts of drugs in the home, and a background check showed multiple prior convictions for firearms offenses. Armed with that information, officers obtained a search warrant for the home. Inside, they found large amounts of drugs, cash, and 8 firearms. Nora was sentenced to 122 months in prison, but he appealed. Nora argued that the officers arrested him from inside his home by verbally ordering him outside, a concept outlined in Payton versus New York. In this case, essentially, by ordering Nora outside of his home, the court found that the officers' authority entered the home without a warrant, even if their actual body did not. Since the arrest occurred without a warrant, the next question was whether or not there were exigent circumstances to make the arrest. The answer? No, there was no exigency. Although Nora ran into the house, the officers controlled the entire outside. That is the point a warrant should have been obtained. Instead, officers made the warrantless arrest and then proceeded to get a warrant based on statements made after the arrest was made. There was no real danger that evidence would be lost, no indication Nora was a danger to anyone in the home. He never pointed the gun at anyone, and the only law officers had reasonable suspicion for was a misdemeanor California crime, carrying a loaded gun in public. And there was no evidence that he was an immediate flight risk since the house was surrounded. All of the evidence after the call-out was suppressed, which, you can imagine, was a big loss for the case. This is another great example of officers doing good police work and likely acting consistent with their training and practices at the time, but not anticipating the court's perspective on the Fourth Amendment. Being proactive is great, and police leaders should foster the environment that makes officers want to catch bad guys. But it's not enough to want to put criminals in jail. Officers have to understand their tools, their options, and their limitations. As case law changes, so do these tools and limitations. If you have any questions or comments, please leave them in the comment section down below. Don't forget to like, follow, and turn on notifications. It really helps the channel grow. Be on the lookout for new videos. They come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Cerbalic. Thanks for watching. Stay safe out there.
Negative.